Hi, my name is Ricardo Weingaart and I'm the Senior Legal Officer at the Law Society of South Africa. And today I'm going to talk about the amendments that were made to the Trust Property Control Act. Now, those amendments were introduced by the General Laws Anti-Money Laundering and Combating Terrorism Financing Amendment Act of 2022. It's quite a long name. I'll just refer to it as the GLA Act. And before I get into the actual amendments that were made to the Trust Property Control Act, let me just talk a little bit about the context. Now, since 2003, South Africa has been a member of the Financial Action Task Force, or FATF for short. Now, FATF has been shaping global anti-money laundering and counter-terrorism financing standards since that time. FATF has developed 40 recommendations which set out a comprehensive framework of measures which member countries should implement in order to combat money laundering and terrorist financing. More recently, the financing of proliferation of weapons of mass destruction was also added to FATF's mandate, and FATF conducts regular country interviews over 10-year intervals aimed at assessing the compliance of member states with the FATF recommendations. And this then results in the publication of a mutual evaluation report in respect of that particular country. So the most recent mutual evaluation report was published in 2021. The process to undertake the mutual evaluation review started in 2019. And as you know, South Africa has been found wanting in terms of its compliance with those recommendations, and that is set out in more detail in the mutual evaluation report. And as a result, South Africa has introduced several measures in order to comply with the FATF recommendation and also the recommendations contained in the mutual evaluation report. Now, the GLA Act represents one of the changes that came about due to this mutual evaluation report. So the Act actually resulted in changes being made to 5 laws. The first one being the Trust Property Control Act, the second one, the Non-Profit Organizations Act, third one, the Financial Intelligence Center Act, fourth one, the Companies Act, and also the last one being the Financial Sector Regulation Act. So there are a couple of themes that are embedded within those laws. First one being beneficial ownership. Now, the laws would introduce a definition, the obligation to disclose, maintaining registers on the part of the regulators, and then also penalties. Another theme is the eligibility of office bearers. And in this context, we specifically refer to the trust and non-profit organizations. To a large extent, those have been addressed in terms of the Companies Act, but there were some minor changes also made to the Companies Act. Another theme is access to information and sharing of information between various organs of state, especially in relation to the issue of beneficial ownership. So let's look at the specific changes that were made to the Trust Property Control Act. Firstly, it inserted new definitions, the one for accountable institution and also for beneficial owner. It also imposed certain requirements and obligations on trustees. It determines which persons are disqualified from being appointed to act as trustee or to continue to act as a trustee. It also clarifies that a person who was appointed outside of South Africa as a trustee, and it also clarifies that a person who was appointed outside of South Africa must be authorized by the master to act as a trustee. It provides for the removal of a trustee who becomes disqualified to continue to act as a trustee. And then it also provides for the information that must be kept by trustees in relation to beneficial ownership of a trust. and it also requires the master of the High Court to maintain a register containing information relating to beneficial ownership of trust, and then it introduces new offences. In summary, the definition of beneficial owner in respect to the provisions of a trust instrument means A natural person who directly or indirectly ultimately owns the relevant trust property. B, a natural person who exercises effective control of the administration of the trust arrangements that are established pursuant to a trust instrument. C, its founder of the trust, and if it's a legal person, the natural person who owns or exercises effective control. D, its trustee. E, its beneficiary, referred to by name. And if it's a legal person, the natural person who owns or exercises effective control. So when we look at this definition, it's clear to me that the beneficial owner may in some instances not actually be identified within the trust instrument. So if you have a natural person who directly or indirectly ultimately owns the relevant trust property, but who is not listed within the trust deed, that person is still, as per the definition, a beneficial owner. Likewise, if a person exercises effective control over the administration of the trust, even if that person is not listed in the trust deed, that person is regarded as a beneficial owner. Part of the intention behind these amendments were actually to assess and determine who are the true owners, now being defined as beneficial owners of the legal entity, and in this context the trust, who may not necessarily be reflected in the formal documentation of the entity, and in this context, in the trust deed or the trust instrument. Now, it's important to have regard to this definition when the beneficial ownership report is being submitted, or let me put it this way, when you prepare to submit the beneficial ownership report, because you need to have that information at your disposal when you complete the beneficial ownership report. So this is quite an important change in terms of the Trust Property Control Act. So let's look at the changes that were made to the body of the Trust Property Control Act. The first one is the change to Section 6, and it introduces Section 1 capital A that deals with persons who are disqualified from being authorized to act as trustees of a trust. Now, it introduces several areas of disqualification. Firstly, for example, an unrehabilitated insolvent. Secondly, a person that has been prohibited by a court to be a director of a company. Another example is a person who is prohibited in terms of any law to be a director of a company. This is, to a large extent aligned with what's in the Companies Act in relation to directors. But also it has introduced specific offenses dealing with theft, fraud, perjury, and then specific laws are being listed. So it's very important that as a trustee or as an advisor of a trust, that you are clear in terms of those specific areas of disqualification, and that those who sign up or raise their hands to be appointed as trustees, that they are clear that they're not disqualified from being authorized as a trustee. So practically what I would recommend is that you actually prepare a document similar to the written confirmation that we find with companies, where directors, before they are appointed, are requested to sign a confirmation declaring that they are not ineligible or disqualified from being appointed as directors. So I would suggest a similar exercise be undertaken in this regard. There's also reference to those who are subject to the Security Council of the United Nations, and under the Financial Intelligence Center Act, on a regular basis issues updated lists of those that are impacted in this regard. So I'm not going to deal with every item of disqualification in detail, but the intention is to allude to the fact that Section 6 has been amended, and it's imperative to have regard to those specific areas of disqualification. And then Section 8 has also been amended, and the intention behind that amendment is to ensure that a foreign trustee shall only act in capacity if authorized thereto in writing by the master. My understanding was that that requirement is in any case applicable to persons who are nominated as trustees. Even if they haven't yet been authorized, they cannot act in that capacity. But as I indicated earlier, the intention is to clarify that specific purpose of the act, of the section. An amendment has also been made to Section 10 of the Trust Act. A new subsection 2 has been introduced, which provides that a trustee must disclose their position as trustee to any accountable institution with which the trustee engages in that capacity, and must make it known to the accountable institution that a relevant transaction or business relationship relates to the trust property. Now, that's the second definition that got inserted in the Act, and that is the definition of an accountable institution. And essentially that definition is found within the Financial Intelligence Center Act, specifically Schedule 1 of the Financial Intelligence Center, and that would, it lists a number of accountable institutions. It would include banks. It also, practicing legal practitioners are included within that definition. So essentially, when the trustee engages with those accountable institutions, that disclosure is required. The next amendment was made to Section 11, and there was another subsection that got added. Now, just to give some context to subsection or Section 11, it provides that a trustee shall indicate clearly in bookkeeping the property being held in capacity as trustee, register the trust property to make it clear that it is trust property, make any account or investment in a financial institution or trust, account, investment, and I mean these issues have been identified by James. So the subsection E that's been added basically requires that the trustees must record the prescribed details relating to the accountable institution which the trustee uses as agents or for the provision of services. Now the detail would be prescribed after consultation with the Minister of Finance and the Financial Intelligence Center, and so that's contained within the regulations that we'll have a look at in a moment. And then what I would think is perhaps the most important change to the Trust Property Control Act is the inclusion of Section 11 capital A, and that's entitled Beneficial Ownership. Now that imposes new obligations on trustees. Essentially it says that a trustee must establish and record the beneficial ownership of the trust. It must also they must also keep a record of the prescribed information relating to beneficial owners, and also lodge a register of prescribed information with the Master of the High Court, and also ensure that that information that we refer to is kept up to date. So that's quite an important obligation that's being introduced in terms of the amendments, and the obligation is imposed upon the trustees. And of course, when the trustees lodge this register, they must have regard to the definition of beneficial owner as well as the regulations. So Section 11 capital A also imposes obligations on the Master of the High Court in order to keep a register of, in the prescribed form, and also to make that information available to those persons prescribed in terms of the regulations. So Section 11A, quite a significant section in my view. So Section 19 also got amended, and it introduces essentially an offence with reference to trustees who fail to comply with specific provisions in terms of the amended Trust Property Control Act. It specifically refers to Section 10, subsection 2, 11, subsection 1E, and 11, capital A, 1. Now, this section or introduction of the offence has sparked some controversy because it specifically refers to a fine not exceeding 10 million or imprisonment of a period of not exceeding 5 years. So I've heard some are saying that this is perhaps subject to constitutional scrutiny because there is a principle in our common law that basically says that the law doesn't concern itself with trivial matters. In my view, this is not trivial. The motivation for the amendments to the legislation is set out in the GLA Act. So I doubt if a trustee would automatically receive a 10 million rand fine for failure to comply with those provisions, and that wouldn't be the default fine in my view. However, there might be instances where that is applicable. Okay, so let's have a look at the regulations that got introduced pursuant to the Trust Property Control Act and to these amendments. Firstly, the information regarding the accountable institution. Now, remember, there is a definition in the Financial Intelligence Center Act that is now echoed within the Trust Property Control Act. So the kind of details that must be recorded, it's the name of the accountable institution. If it's a legal person, the registration details of that person. If it's a natural person, the official identity number or passport number. Also, if the accountable institution is used as an agent to perform some of the trustee's functions, the nature of those functions. And then also, if it's services, the nature of the services, and also if it's a single transaction or a business relationship. So that's the kind of information, an additional compliance obligation in relation to accountable institutions. So of course it's important to have a look at which institutions are listed in the Financial Intelligence Center Act as accountable institutions. With regards to beneficial ownership, the following details must be recorded and submitted as part of the register, and that's the full names, date of birth, nationality, ID or passport number, and also country of issue, citizenship, residential address, the beneficial owner's address of service, means of conduct, if a South African taxpayer, the tax number, class or category of beneficial owner. Now this relates to the definition that got introduced in the Trust Property Control Act. But that's also set out in the specific form, and the date on which the beneficial owner and the date on which the person became a beneficial owner and on which the person ceased to be a beneficial owner. Now we're going to look at a short video that illustrates how the beneficial ownership register gets completed.